Commercial leases in France are highly regulated and to a considerable degree standardized by the French statute law, mainly within the decree dated 1953, embodied in the commercial code under many articles such as 145 article and following of the commercial code. Some of the following points are quite different from the other laws and common law system. A standard 9 years term for French commercial lease is fixed by statute, but the lease has breakpoints every 3 years, allowing the tenant, and only him, to bring the lease to an end, provided a 6 months prior very formal notice. There is a statutory right of renewal for the tenant. From the landlord's perspective, in order to avoid an automatic renewal of the existing conditions, he must give notice, at least 6 months before the end of a 9 years term. But this notice period could be made longer contractually. The method and timing of rental index linkage to increase the rent is completely provided and framed by the law. The termination of the lease is subject to highly constraining procedural requirements, which, if not complied with, tend to embarrass the landlord. The tenant has an absolute right to complete the 9 years term and, moreover, a statutory right to receive a renewal offer for further 9 years period of time, albeit more than probably at an increased rental amount. However, he also has the possibility of bringing his tenancy to an end at the end of each 3-year period of his lease. Short-term leases also exist. The most likely short-term lease to be encountered is for 23 months duration, but very great care must be taken care of to avoid its automatic transformation into a standard 9 years lease, for example, by the tenant remaining in the premises for a period over 23 months. It is very rare in France to encounter commercial leases with have a term of duration over 9 years, but sometimes leases of 12 years term are found which are outside the statutory framework, and care should be taken before entering such an agreement. Compensation called indemnité d'éviction is set by a judicial expert appointed by the district civil court, and often based on the turnover of a business, is nevertheless payable to the tenant by the landlord at the end of the term of a lease.